Hi, everybody. So, Ozark Orak of the Lifeboat Shelter in downtown Astoria wants his gun rights back. He has been less than honest about his felony record. I was hoping to find some good podcasts about gun law, and I watched a bunch of stuff, but it was more from a gun rights perspective. And I thought about just something more dry and academic of reading the actual law into a video blog. If anybody wants to comment, I'm going to try to keep this dry and free of opinion because I want to become more well versed in the Oregon gun law. It's not a subject I study or really care to study very much, but Oregon Revised Statutes 166, Oregon Revised Statutes. So the text of it, any any person who has been convicted of a felony under law of this state or any other state, or who has been convicted of a felony under the laws of the government of the United States, who owns or has in the person's possession or under arm commits the crime of felon in possession of a firearm. And for the record, Ozark did commit that crime, but when he did a plea bargain, they dropped that charge if he would plead to burglary. And I believe that was about 10 years ago. Any person who has been convicted of a felony under the law of this state or any other state, or who has been convicted of a felony under the laws of the government of the United States, who owns or has in the person's possession or under the person's custody or control any instrument or weapon having a blade that projects or swings into position by force of a spring or centrifugal force, or any blackjack, slingshot, sand club, sandbag, sack glove, metal knuckles, or an electromuscular disruption technology device, as defined in Oregon Revised Statute 165.540, obtaining contents of communications while, or who carries a dirk, dagger, or stiletto, commits the crime of felon in the possession of a restricted weapon. 3, for the purpose of this section, a person who has been convicted of a felony, if at any time of conviction for an offense, that offense was a felony under the law of the jurisdiction in which it was committed, such conviction shall not be deemed a conviction of a felony if the court declared the conviction to be a misdemeanor at the time of judgment, or B, offense was possession of marijuana and the conviction was prior to January 1, 1972. 4, subsection 1 of this section does not apply to any person who has been A, convicted of only one felony under the law of the state or any other state, or who has convicted of only one felony under the laws of the United States, which felony did not involve criminal homicide, as defined in Oregon Revised Statute 163.005, criminal homicide, or the possession or use of a firearm or a weapon having a blade that projects or swings into position by force of a spring or by centrifugal force, who has been discharged from imprisonment, parole, or probation for said offense for a period of 15 years prior to the date of alleged violation of subsection, or granted relief from the disability under 18 U.S. Code 925C or Oregon Revised Statute 166.274, relief from prohibition against possessing or receiving firearm, or has had that person's record expunged under the laws of the state or equivalent laws of another jurisdiction. Felon in possession of the firearm is a Class C felony. Felon in possession of a restricted weapon is a Class A misdemeanor. And in particular to this case at 145 in Clatsop County, it is my understanding that the charges in which he was charged for felon in possession of a firearm, he's paid. I've been monitoring it for a few years, but he had gone to the courthouse and paid certain fees for an expungement. So expungement is itself a very interesting side of the law. And when I spoke to Kenny Hansen yesterday about the whole issue, which he agreed was a very interesting, the issue of just Oregon being light on crime is kind of the bigger overarching issue. Relief from firearm position. Okay, let's see. Well, let's just keep going. So let's go to, well, 166.272. Oh, verifying your amendment. I don't. Okay. Unlawful possession of machine guns, certain short-barreled firearms, and firearms silencers. Text. A person commits the crime of unlawful possession of a machine gun, short-barreled rifle, short-barreled shotgun, or firearm silencer if the person knowingly possesses any machine gun, short-barreled rifle, short-barreled shotgun, or firearm silencer. 2. Unlawful possession of a machine gun, short-barreled rifle, short-barreled shotgun, or firearm silencer is a Class B felony. 3. A peace officer may not arrest or charge a person for violating subsection 1 of this section if the person has in the person's immediate possession documentation showing that the machine gun, short-barreled rifle, short-barreled shotgun, or firearm silencer is registered as required under federal law. 4. It is an affirmative defense to a charge of violating subsection 1 of this section that the machine gun, short-barreled rifle, short-barreled shotgun, or firearm silencer was registered as required under federal law. Okay. Next section 166.273, relief from firearm prohibitions related to mental health. 1. A person barred from transporting, shipping, possessing, or receiving a firearm may file a petition with the Psychiatric Security Review Board for relief from the bar if A. The person is from possessing a firearm under ORS 166.250, unlawful possession of firearms. B. The person is barred from receiving a firearm under ORS 166.470, limitations and conditions for sale of. And to go back, that's for certain felons. 1E or F, or if the person has been found guilty except for insanity of a misdemeanor involving violence, ORS 166.470, limitations and conditions for the sale of firearms. 1G or C, the person is barred from possessing, receiving, shipping, or transporting a firearm under 18 U.S. Code 92 D4 or G4 as the result of a state mental health determination. The petitioner shall serve the copy of the petition on A, the Department of Human Services and the Oregon Health Authority, and B, the district attorney in each county in which the person was committed by a court to the Oregon Health Authority or adjudicated by a court as a person with mental illness under ORS 426.130, court determination of mental illness. B, the person was committed by a court to the Department of Human Services or adjudicated by a court as in need of commitment for residential care, treatment, and training under ORS 427.290, determination by court of need for commitment. C, the person was found guilty except for insanity under ORS 161.295, affective qualifying mental disorder. D, the person was found responsible except for insanity under ORS 419C.411, disposition order, or E, the person was found by a court to lack fitness to proceed under ORS 370, determination of fitness to proceed. Okay, so let me look back. Following the receipt of the petition, the board shall conduct a contested case hearing, make written findings of fact and conclusions of law on the issues before the board, and issue a final order. Board members from the adult panel, the juvenile panel, or a combination of both panels of the board may conduct the hearings described in this section. 4, the state and any other person or entity described in subsection 2 of this section may appear and object to and present evidence relevant to the relief sought by the petitioner. The board shall grant the relief requested in the petition if the petitioner demonstrates, based on the petitioner's reputation, the petitioner's record, the circumstances surrounding the firearm disability, and any other evidence of record, that the petitioner will not be likely to act in a manner that is dangerous to public safety, and that granting the relief would not be contrary to the public interest. If the board grants the relief requested in the petition, the board shall provide to the Department of State Police the minimum information necessary as defined in Oregon Revised Statute 181A.290, certain information required from agencies to enable the department to A, maintain the information and transmit the information to the federal government as required under federal law, and B, maintain a record of the person's relief from the disqualification to possess or receive a firearm under Oregon Revised Statute 166.250, unlawful possession of firearms, 1C, D, or E, or 166.470, limitations and conditions for the sale of firearms, 1E, F, or G. The petitioner may petition for judicial review of final order of the board. The petition shall be filed in the circuit court of the county described in subsection 2B of this section. The review shall be conducted de novo and without a jury. 8, the petitioner may take an appeal from the circuit court to the Court of Appeals. Review by the Court of Appeals shall be conducted in accordance with Oregon Revised Statute 183.500 appeals. 9, a person may file a petition for relief under the section no more than once every 2 years. 10, the board shall adopt procedural rules to carry out the provisions of this section. 11 is used in this section. State mental health determination means A, a finding by the court that a person lacks fitness to proceed under Oregon Revised Statute 161.370. a finding that the person is guilty except for insanity of a crime under Oregon Revised Statute 161.295, effective a qualifying mental disorder, or responsible except for insanity of an act under Oregon Revised Statute 419C 411, disposition order, or any determination by the Psychiatric Security Review Board thereafter. A commitment by a court to the Oregon Health Authority, or an adjudication by a court that a person is a person with mental illness under Oregon Revised Statute 426.130, court determination of a mental illness, or a commitment by a court to the Department of Human Services, or an adjudication by a court that a person is in need of commitment for residential care, treatment, and training under Oregon Revised Statute 427.290, determination by court of need for commitment. Okay. 166.274, relief from prohibition against possessing or receiving a firearm. Except as provided in subsection 11 of this section, a person barred from possessing or receiving a firearm may file a petition for relief from the bar in accordance with subsection 2 of this section if the person is barred from possessing a firearm in Revised Statute 166.250, unlawful possession of firearm 1C, A, C, or H, or 166.270, possession of weapons by certain felons, or the person is barred from receiving a firearm under Oregon Revised Statute 166.470, limitations and conditions for the sale of firearms, 1A or B, or if the person has been convicted of a misdemeanor involving violence, Oregon Revised Statute 166.470, limitations and conditions for the sales of firearms. 2. A petition for the relief described in this section must be filed in the circuit court of the petitioner's county of residence. 3. A person may apply once per calendar year for relief under the provisions of this section. 4. Left blank. A person petitioning for relief under this section shall serve a copy of this petition on A. The city chief of police of the court in which the petition is filed is located in the city, or the sheriff of the county in which the court is located. B. The copy of the petition shall be served on the chief of police or sheriff at the same time the petition is filed at the court. 5. A. When a petition is denied, the judge shall cause that information to be entered into the Department of State Police computerized criminal history files. B. When the petition is granted, the judge shall cause that information and a fingerprint card of the petitioner to be entered into the Department of State Police computerized criminal history files if, after a petition is granted, the petitioner is arrested and convicted of a crime that would disqualify the petitioner for purchasing or possessing a firearm. The Department of State Police shall notify the court that granted relief under this section. The court shall review the order granting relief and determine whether to rescind the order. The Department of State Police may charge a reasonable fee under Oregon Revised Statute 192.324, copies of inspection of police records, for the entry and maintenance of information under this section. 6. Notwithstanding the provisions of Oregon Revised Statute 9.320, necessity for employment of attorney, a party that is not a natural person, the state or any city, county, district, or other political subdivision of public corporation in this state, without appearance by attorney, may appear as a party to an action under this section. 7. If the petitioner seeks relief from the bar on possessing or purchasing a firearm, relief shall be granted when the petitioner demonstrates by clear and convincing evidence that the petitioner does not pose a threat to the safety of the public or the petitioner. 8. Petitions filed under this section shall be heard and disposed of within 15 judicial days of filing, or as soon as practicable thereafter, but not more than 30 days thereafter. The judge shall then make findings and conclusions and issue a judgment based on the findings and conclusions in accordance with the requirements of law. A person filing a petition under this section must pay the filing fee established under Oregon Revised Statute 21.135, standard filing fee. So what I'm realizing is that the judge may not even issue a decision today, may take it under advisement, may want to consult all these laws. And what it looks like is if, say, Osarch Orak does then commit a crime, there would the court shall review the order grant and determine whether to rescind. The order could be rescinded. Okay, this yes. Okay. Whew. Okay. Okay. All right. Well, let's just move along. 166.275 Possession of weapons by inmates of institutions. Any person committed to any institution who, while under the jurisdiction of any institution or while being conveyed to or from any institution, has under the custody or control of the person any dangerous instrument or any weapon, including but not limited to any blackjack, slingshot, billy, sand club, metal knuckles, explosive substance, dirk, dagger, sharp instrument, pistol, revolver, or other firearm without lawful authority is guilty of a felony and upon conviction thereof shall be punished from imprisonment in the custody of Department of Corrections for a term not more than 20 years. Okay, forfeiture 166.279 Forfeiture of deadly weapons, except as provided in subsection 4 of this section. Okay, and just for the record, the homeless have told me that Ozark Orak had an arsenal of weapons on the boat that he had burgled, just arsenal, because that's where he dealt his methamphetamine. Okay, so except as provided in subsection 4 of this section, Oregon Revised Statute 131.550, definitions for Oregon Revised Statute 131.550 or 131.600 to 131.600 record keeping and reporting requirements do not apply to the forfeiture of a firearm or other deadly weapon that was possessed, used, or available for use to facilitate a criminal offense. Except as provided in subsection 3 of this section, at the time of sentencing for any criminal offense in which a firearm or other deadly weapon was possessed, used, or available for use to facilitate the offense, the court shall declare the weapon to be contraband and order that weapon be forfeited. If a firearm or other deadly weapon that was possessed, used, or available for use to facilitate a criminal offense was stolen from its lawful owner, I would love to just call Officer McNeary. I don't have his number. And be like, what do you feel about Ozark having guns? Because Officer McNeary is the officer he lied to about the gun in his backpack. It was recovered from a person other than the lawful owner when he was a felon doing a burglary. The court may not order that weapon to be forfeited, but shall order that the weapon be restored to the lawful owner as soon as the weapon is no longer needed for evidentiary purposes. Oh, yes. Okay. The court shall release the firearm or other deadly weapon forfeited under subsection 2 of this section to the law enforcement agency that seized the weapon. The law enforcement agency may destroy or sell the weapon, use the weapon as a service weapon, or use the weapon for training, identification, for demonstration purposes. When a weapon is sold pursuant to the subsection, the law enforcement agency shall pay the proceeds from the sale, less the costs of the sale as provided in Oregon Revised Statute 131.594, disposition and distribution of forfeited property when seizing agency, not the state. 131.597, disposition and distribution of forfeited property when seizing agency is the state. Okay, 166.282, sale of weapons by political subdivision. A political subdivision in the state that sells a weapon described in subsection 2 of this section shall pay the proceeds from the sale of the weapon, less the costs of the sale, to the account of the police agency that received the weapon to be used for purposes of public safety, law enforcement, and crime prevention and detection. Okay. 166.21, issuance of a concealed handgun license, application fees, liability. The person's application for an Oregon concealed handgun license, upon receipt of the appropriate fees and after compliance with the procedures set out in this section, shall issue the person a concealed handgun license if the person, A, is a citizen of the United States, B, is a legal resident non-citizen who can document continuous residency in the county for at least 6 months and has declared in writing to the United States Citizen and Immigration Services the intent to acquire citizenship status and can present proof of the written declaration to the sheriff at the time of this application of the license, is at least 21 years of age, is a resident of the county, has no outstanding warrants for arrest, is not free on any form of pretrial release, demonstrates competence with a handgun by any one of the following: completion of a hunter education or hunter safety course approved by the State Department of Fish and Wildlife or a similar agency of another state if handgun safety was a component of the course, completion of any National Rifle Association firearm safety or training course if handgun safety was a component of the course, completion of any firearm safety or training course or class available to the general public offered by law enforcement community college or private or public institution or organization or firearms training school utilizing instructors certified by the National Rifle Association or law enforcement agency of handgun safety was a component of the course. Completion of any law enforcement firearms safety or training course or class offered for security guards, investigators, reserve law enforcement officers, or any other law enforcement officers if handgun safety was a component of the course presents evidence of equivalent experience with handgun through participation in organized shooting competition or military service, is licensed or has been licensed to carry a firearm in the state unless the license has been revoked, completion of any firearms training or safety course or class conducted by a firearms instructor certified by a law enforcement agency or the National Rifle Association, if handgun safety was a component of the course, has never been convicted of a felony or found guilty, except for insanity under Oregon Revised 161.295, effective qualifying mental disorder or felony. Nick told me this on the river last night, that if you've had a felony, you are never getting a concealed handgun license. So that's great. Has not been convicted. And yesterday I spoke to a felon who's like, I always carry a handgun. And there's that. Has not been convicted of a misdemeanor or found guilty except for insanity under ORS 161.295, effective a qualifying mental disorder of a misdemeanor within the 4 years prior to the application, including a misdemeanor conviction for the possession of marijuana as described in paragraph L of this section. I has not been committed to the Oregon Health Authority under Oregon Revised Statute 426.130, has not been found to be a person with mental illness and is not subject to an order under Oregon Revised Statute 426.130, court determination of mental illness, that the person be prohibited from purchasing or possessing a firearm as a result of that mental illness. K has been discharged from the jurisdiction of the juvenile court for more than 4 years if, while a minor, the person was found to be within the jurisdiction of the juvenile court for having committed an act that, if committed by an adult, would constitute a felony or misdemeanor involving violence, as defined in Oregon Revised Statute 166.470, limitations and conditions for sales of firearms. L has not been convicted of an offense involving controlled substance or participated in court supervising drugs diversion program, except this disability does not operate to exclude a person if A, the person can demonstrate that the person has been convicted of only once of a marijuana possession offense that constituted a misdemeanor or violation under the law of the jurisdiction of the offense and has not completed a drug diversion program for a marijuana possession offense that constituted a misdemeanor or violation under the law of the jurisdiction of the offense. B, the person can demonstrate that the person has only once completed a drug diversion program for a marijuana possession offense that constituted a misdemeanor or violation under the law of the jurisdiction of the offense and has not been convicted of a marijuana possession offense that constituted a misdemeanor or violation of the law of the jurisdiction of the offense. M is not subject to a citation under Oregon Revised Statute 163.735 or an order issued under Oregon Revised Statute 30.866, action for issuance of violation of stalking protective order or to 107. So that's 30.866, 107.735, duties of a state court administrator, 163.738, effective citation, has not received a dishonorable discharge from the armed forces of the United States, is not required to register as a sex offender in any state, and is not presently subject to an order under Oregon Revised Statute 426.133, assisted outpatient treatment prohibiting the person from purchasing or possessing a firearm. A person who has been granted relief under Oregon Revised Statute 166.273, relief from firearm prohibitions relating to mental health, 166.274, relief from prohibition against possessing or receiving firearm, or 166.293, denial or revocation of license, or 18 U.S. Code 925C, or has had the person's record expunged under the laws of the state or equivalent laws of other jurisdictions, is not subject to the disabilities in sections 1G to L of this section. What? I'm sorry. Well, I'm just going to keep going. Before the sheriff may issue a license, the application must state the applicant's legal name, current address and telephone number, date and place of birth, hair and eye color and height and weight. The application must also list the applicant's residence address or addresses of the previous 3 years. The application must contain a statement by the applicant that the applicant meets the requirements of subsection in this section. The applicant may include the social security number of the applicant. If the applicant voluntarily provides the number, the application must be signed by the applicant. The applicant must submit to fingerprinting and photographing by the sheriff. The sheriff shall fingerprint and photograph the applicant and conduct any investigation necessary to corroborate the requirements listed under subsection of this section. If the nationwide criminal records check is necessary, the sheriff may request the Department of State Police to conduct the check, including fingerprint identification through the Federal Bureau of Investigation. The Federal Bureau of Investigation shall return the fingerprint cards used to conduct the criminal records check and may not keep any record of the fingerprints. The Department of State Police shall report the results of the fingerprint-based criminal records check to the sheriff. The Department of State Police shall furnish the sheriff with any information about the applicant that the Department of State Police may have in its possession, including but not limited to manual or computerized criminal offender information. Application forms for concealed handgun license shall be supplied to the sheriff upon request. The forms shall be uniform throughout the state in substantially the following form. Date: I hereby declare as follows. I'm a citizen of the United States or legal resident non-citizen who can document continuous residency in the county for at least 6 months and have declared in writing to the United States Citizenship and Immigration Services my intention to become a citizen and can present proof of the written declaration to the sheriff at the time of this application. I'm at least 21 years of age. I've been discharged from the jurisdiction of the juvenile court for more than 4 years. If, while a minor, I was found to be within the jurisdiction of the juvenile court for having committed an act that, if committed by an adult, would constitute a felony or misdemeanor involving violence as defined by Oregon Revised Statute 1664.470, limitations and conditions for sales of firearms. I've never been convicted of a felony or found guilty except for insanity under Oregon Revised Statute 161.295, except of qualifying mental disorder of a felony in the state of Oregon or elsewhere. I have not within the last 4 years been convicted of a misdemeanor or found guilty except for insanity under Oregon Revised Statute 161.295, effective of qualifying mental disorder of a misdemeanor, except as provided by Oregon Revised Statute 166.291, issuance of a concealed handgun license. 1L1, have not been convicted of an offense involving controlled substances or completed a court-supervised drug diversion program. There are no outstanding warrants for my arrest, and I'm not free on any form of pretrial release. I've not been committed to the Oregon Health Authority under Oregon Revised Statute 426.130, court determination of a mental illness, nor have I been found to be a person with mental illness and presently subject to an order prohibiting me from purchasing or possessing a firearm because of mental illness. I'm not under a court order to participate in assisting outpatient treatment that includes an order prohibiting me from purchasing or possessing a firearm. If any of the previous conditions do apply to me, I have been granted relief or wish to petition for relief from the disability under Oregon Revised Statute 166.273, relief from firearms prohibition relating to mental health, 166.274, relief from prohibition against possessing or receiving a firearm, or 166.293, denial of revocation of license, or 18 U.S. Court 925C, or have the records expunged. I'm not subject to a citation issued under Oregon Revised Statute 163.735 citation or an order issued under Oregon Revised Statute 30.866 action for issuance or violation of stalking protective order, 107.700 short title, or 107.735 duties of state court administrator, or 163.738 effective citation. I have never received a dishonorable discharge from the armed forces of the United States. I'm not required to register as a sex offender in any state. I understand, and I will be fingerprinted and photographed. Okay. Social Security number is voluntary, so it's authorized under Oregon Revised Statute 166.291, issuance of a concealed handgun license. Okay, my lungs are getting tired. I want to switch channels. I'm tired of this. But I have friends who have been assaulted by him. I have friends who say their family members burgled houses in an armed manner. I have friends who say he perjured himself on the stand when testifying against a person who did not commit the gun crime that he possibly committed himself. I've read the police files from Gresham regarding his dog theft. I've spoken to numerous people who've purchased methamphetamine from Osarch Orak. I continue to urge the councils of Clatsop to issue extreme caution when allowing a notorious abuse. I've even reported him to the police numerous times for stealing mail, which is a federal offense. But due to the lack of prosecution and his immunization through the conflict of interest inherent in his board with Kirk Wintermute, he sort of got a blank check. and I'm thinking tabula rasa. Yep, a tabula rasa, a blank slate.